Very well. Now being 7 o'clock, the regular meeting of the zoning board of appeals of the town of Orleans is called to order by myself, Michael P. Marnick, the chair. Also present with me are associate members Gerald Mulligan and Emily Von Giesen, and regular members Matthew Cole, Peter Jablin, and Beth McCartney. Also present are the board secretary Sandy Stewart and the building commissioner of the town of Orleans, Tom Evers. I would ask that those of you who have smartphones or other electronic objects which may interrupt the train of thought of others in this meeting do what I am going to do and either place it on stun or eliminate it altogether.
I didn't know we had that setting.
Our calendar for the evening are as follows. First, some housekeeping. The minutes of the last regular meeting of October 4th were circulated amongst the members, and it would be in order to amend or approve those minutes on a proper motion.
I so moved.
To move to approve?
Yes.
Very well. Is there a second?
Second.
Any discussion on the motion? All those in favor?
Aye.
And opposed? Motion carries unanimously. There are three cases for hearing. The first case is case number 2072, the application of Tamara Fush Gamache for a special permit. Under separate correspondence, the board has received a letter from David A. Little on behalf of the applicant requesting that the subject hearing be continued to November 15th, 2017. And a reason was given, and that is the Conservation Commission is requiring a change to the proposed location of the proposed cottage. I have, through the board secretary, have advised Mr. Little that we would consider that to be a motion to continue, and I would recommend it as the chair to be allowed. Is there a motion to continue case number 2072 till November 15th, 2017?
So, I make,
Thank you, Mr.
Yes.
Jablin. Is there a second?
Second.
Is there any discussion on the motion? All those in favor
aye.
and opposed? Very well. I think that we'll need it's customary to have
Well, I think his letter is,
sufficient writing. Very well. Then we have the following cases remaining to be heard. Case number 2073 is the appeal of the Board of Trustees of the Oaks Condominium from the decision of the Architectural Review Committee as set forth in General Laws, Chapter 48, Section 8, and under Orleans zoning bylaw, Sections 164.33.1, 164.33.1 D4 and 164.33.1E. This property is located at 22 Main Street, Orleans map number 25, parcel number 59. To consider this will be the regular members in attendance and Mr. Mulligan, who will be the five, although our procedure has been to allow all members present, even if they're not voting, to inquire and discuss. Does any member present have had any communication with the applicant or any of the applicant's agents which ought to be disclosed to the public and otherwise constitute a conflict of interest? There is no positive response. Therefore, I declare the members of the board to be indifferent and impartial. You may proceed, sir.
Thank you, Mr. Chairman.
For the record, my name is Brian Wall. I'm an attorney, and I'm here tonight representing the Board of Trustees of the Oaks Condominium, which is a 50-unit residential condominium in downtown Orleans located off Locust Road. The property directly abuts the proposed project, which is a metallic warehouse building. This is included in my materials that I gave to the board as part of my appeal. It's a two-story building, 24.75 feet high, 92.5 by 80 feet long, 7,400 square feet. And before you tonight is an appeal of a decision that was made by the Architectural Review Committee approving the proposed project. I'm sure the board is fully aware of the provisions of the zoning bylaw, being the Board of Appeals, but you may not have had too many of these particular appeals. Part of the Orleans bylaw delegates authority to the Architectural Review Committee to review projects insofar as architecture is concerned. And I won't belabor and go into it too much, but just briefly I want to review. The purpose of the bylaw is to preserve and enhance the town's cultural and economic and historic resources by providing appearance and structures and sites which may affect these resources. The primary purposes of the bylaw are to prevent new construction or alterations that are incompatible with older existing buildings and styles, to promote conservation of buildings and groups of buildings that have aesthetic and historic significance, to enhance the social and economic viability of the town by preserving property values and promoting visual attractiveness, and to encourage flexibility and variety in the future development. These purposes are effectuated by a review process that requires the committee to go through 14 very specific design criteria and then issue a decision. The primary purpose, again, being to make sure that the development is compatible with its surroundings. And we have some photos that Mr. Earhart, one of the trustees, can help me with here. We canvassed the neighborhood and took a view of what's around. And let me begin by referring to the assessing map. I'm going to stand up to make this a little easier. This is Main Street, and this is the Snows property. I'm sorry, this is Main Street. This is the Snows property here that goes back. This is the condominium here. So although the address of the project site is 22 Main Street, the site of the project is back here where my finger is. And so the surrounding area is actually much more residential, although it is in a general business district, but it has been developed residentially. These are the condo that is Oaks Condominium here. These are all residences which are shown on the map, the graphics here, Locust Road, and also on Main Street down towards the end.
Sir, would you like that easel over there? Would that help you?
I think I'm done for now. Thank you for the offer, though. I do have an easel, but I forgot to bring it. But in any event, I think I'm okay. So, having said that, we have two arguments that are relatively simple and straightforward to make to you. The first of which is a procedural one, that in the bylaw, there are provisions regarding what the purpose and role of the ARC is, and it's very clear in the requirement that the committee's decision must contain, and I'm going to quote the bylaw, specific written findings relating to compliance with the design criteria. And the first argument that we have to present to you tonight is that if you review the board's decision, the committee's decision, they did not make any findings whatsoever. And so under the bylaw, it's procedurally deficient, and we would argue needs to be vacated and remanded. It's our view that there are two reasons why the bylaw requires specific written findings. One is to provide the ability of the Zoning Board of Appeals and potentially a court of law to be able to review the basis of the decision. So when a party such as my client files an appeal and a board such as you have to decide whether the decision is appropriate or not, you have to be able to figure out what was going on in the minds of the board members that made the decision, and hence the requirement for specific written findings. And there are none in this decision, zero. There are no findings whatsoever. The second is The second reason why findings are very important, in my view, is that it requires or forces discipline and rigor in the decision-making process, so that the decision-making body goes through the 14 design criteria that town meeting put into the bylaw. And the board, the committee, did not go through those criteria, and it's evidenced by the fact that there's no findings in the decision. Secondly, which segues to the 14 criteria, had the board rigorously followed the bylaw and went through the 14 different criteria, it's our contention that the decision would have been not to approve this proposed project. I'm not going to go through all 14 of the criteria because I presume the board is somewhat familiar with it, but I want to highlight a couple of the more important ones. Scale. The proposal demonstrates balanced proportions in relation to height and width, roof shape and pitch, and windows and doors. Scale should be consistent with the other structures in the surrounding area. The particular building is 7,400 square feet of a footprint. Now, the applicant has said and pointed out that the condominium buildings are approximately half that footprint. One is about 3,500 and the other is about 2,800. And the applicant makes the position back to the ARC that the condominiums have second floors and lofts and basements, and therefore when you put the cubic volume of them together, the buildings are somewhat comparable. We would beg to differ. 7,400 square feet is the footprint. It's 25 feet high, almost 24.75 feet. When you do the volume, the building that's proposed is twice as large as the largest condominium and significantly bigger, to a scale of 4 to 5 times bigger than the residential dwellings that are in the neighborhood that surrounds this particular property. So had the board looked at the scale very carefully, the board should have found that it was out of scale with the neighborhood. Very similar, the next standard is massing and bulk. And that standard requires that there be an overall relationship between the building size and scale and the lot, and consistent with the surrounding properties. Nearby structures built in proportion to one another are desirable. Again, had they gone through that criteria, I respectfully submit they should have determined that a building that's 4 times bigger than most of the surrounding structures and twice as big as the condominium buildings should not have been approved. Next, building materials. The exterior siding, roof, windows, doors, and trim should be compatible with desirable and traditional materials used in the community. The building has a metal roof. We give credit to the applicant. Mr. Snow did offer and propose to put, and not to us, by the way, but to the ARC, to put cedar shingles on one of the sides. But the metal roof is still very much exposed, as are the metal ends and the doors. The roof itself is one of the standards. Shapes and angles of roofs should be consistent with surrounding roof shapes and pitches to maintain a visual balance. We all know, being Cape Codders, that if you build a Cape Cod home, a 14-pitch roof is really pretty much standard. This is a very low, gradual pitch roof that's out of style with all of the other structures in the neighborhood. And finally is fenestration. The patterns of windows and doors should maintain a balance that conveys a sense of function and scale. The building has no windows, so it doesn't meet that standard whatsoever. What this is essentially about is my clients live in a residential property. This property where the building is proposed is wooded. In fact, when Snow's expanded a few years ago and had to go to the Cape Cod Commission in order to be eligible for DRI approval, the particular area that the building is proposed was put under a conservation restriction. That has since been removed, and Mr. Snow made a cash payment to the town to buy other land to replace that. But the point being is that he's essentially trying to put a warehouse in a neighborhood, and that's not appropriate under the architectural standards. And so for the reasons I've articulated, the decision's procedurally deficient, unable to be reviewed, it needs to be sent back. And secondly, on the merits, the decision should not have been to approve the project. It should have been to deny the project.
Very well. You're absolutely correct. This is the first time since I've been on the board that we've had a chance to review or take an appeal from a decision of the Architectural Review Commission. Now, and I understand your argument, and you've submitted it very well in writing as well. I've read it. But I need to know exactly what I think the board has to know exactly what your positions are. Are you claiming that the Architectural Review Commission had to have made a finding as to each of the 14 criteria?
No, let me read you to answer that, I'll just read straight from the bylaw.
Says it has to consider all of them,
Yeah.
but would you say that the decision would have been a nullity without having referred to each and all of them, such as the fenestration, when the plans showed, for example, that there weren't any windows?
Bear with me 1 minute, please. The bylaw says that the committee's decision shall contain specific written findings relating to compliance with the design criteria.
Very well.
So I understand your question, and if I understand it correctly, you're asking me if they went through 12 instead of 14, would I be making this argument?
Yes,
Probably not,
okay.
but I would.
Okay, now, I have a writing, which appears to be the final, the plan review report, dated August 24th, 2017, and I think this is the writing from which you're asking the zoning board to appeal. There is a section referring to findings. Are you saying that there's no way that those words can be reasonably construed or interpreted to deal with the consideration that the Architectural Review Committee gave to some of the 14 criteria?
I would argue that the language in the section of the decision that says findings are actually conditions of approval, not findings.
Boy, I don't understand you.
In other words, I was there when the committee made its decision, and the committee had listened to the applicant, and the applicant had made a number of design changes throughout the process to try to persuade the committee to approve the project, including the shingles on the side that I mentioned earlier, the ash gray color, cedar shingles, trim and edge of roof. These are all conditions of approval that the committee felt, let me rephrase that the committee accepted from the applicant and incorporated into its decision. I would argue they are not findings under the design criteria.
So those words should have been entered in that area of the form as approval with modifications, and those would have been the concessions, although a reasonable person could determine if there were findings that they dealt with several different of the criteria.
I see where you're going. In my humble opinion, yes, I think that the language under findings should have been more properly included in approved with modifications or approved as stipulated by the applicant. But I would respectfully beg to differ with where you're going with this, because I think if you look at the bylaw, it says specific written findings in relation to compliance with the design criteria. And I didn't read all the design criteria, but I think it's important to understand. Character is one, architectural details, scale, massing in bulk, building materials, roof, fenestration. Those are just the ones that I felt were most relevant. There are 14 in total. And I would respectfully submit to you that if you go through these findings, you don't find any reference to the 14 design criteria.
Some reasonable interpretation of the words entered after findings could determine, we could find that the Architectural Review Committee did consider those criteria with the words they've entered as findings. I'm not arguing with you, but we need to know, you've made a two-pronged argument. The first is that the report is invalid or unenforceable, and the original applicant ought to go no further, or this board ought to reverse it and remand it. Is that the relief that you're looking for? Claiming that the decision is inartfully drawn and does not comply with the enabling sections of the zoning bylaw. Is that what you're saying?
That's a fair statement of what I'm saying,
So,
yes.
is it your position then that this board cannot hear evidence tonight and make its own finding concerning those 14 criteria?
Yes, because the zoning bylaw delegates initial authority to decide whether the project satisfies the design criteria to the Architectural Review Committee, and then places upon this board authority to review its decision. And in order to conduct that review, there needs to be sufficient findings so that this board can decide or know what the committee was thinking when it made its decision.
Fine, and then under those circumstances then, if we determined that there were sufficient findings, what is the scope of review by the zoning board? Do we look at those findings and those criteria de novo and hear evidence again? Or are we required to support those findings and the approval unless we find, say, substantial evidence to the contrary?
Very good question. The bylaw is silent.
What is,
Yeah.
The bylaw is silent.
Silent on
But
that.
from a point of view of administrative law, what is your position? Because I'd like some help for myself and the members here.
So my position on that would be that your review is as administrative in the sense that, and again, I think the bylaw supports this interpretation for the following reason. Town meeting enacted a zoning bylaw in Orleans. Under Chapter 40A, the Zoning Board of Appeals has authority to be the special permit granting authority, or sometimes the planning board. But town meeting, in this particular instance, decided, in its wisdom, to create a separate architectural review committee whose sole purpose is to be familiar with buildings and architecture and the criteria that are set forth in that bylaw. And hence, this board, when it reviews that decision, acts almost in an appellate capacity and looks down and sees whether they followed the bylaw, whether they made their findings, whether they consider the design criteria, and then give some deference to their decision.
Well, you're precisely correct. Ordinarily, the Architectural Review Committee, if it's involved in any application for a special permit or a variance, may have already passed on that petitioner's trip here, which is kind of what's happening
Coming up
in
next.
the next number.
Right.
What I'm struggling with is your position is that if there were findings, then there would be some deference, although we could make our own decision. But there's no findings, so we have no choice but to send it back to the Architectural Review Commission and to clean up its act and make the findings that it could have made, although I wasn't there either, based on whatever evidence it heard, or to have further evidence taken to determine compliance, as the zoning bylaw said, compliance with those 14 criteria.
I would agree.
Yeah.
And by further way of analogy, it sounds like you might have some legal background with the way you're asking me these questions, but if you're familiar with the appeal from a zoning board, it's a hybrid standard of review where it goes to the Superior Court. The court finds the facts de novo, but then compares those facts to the board's decision and provides some deference to the decision-making authority to see if the findings are not unreasonable, whimsical, or arbitrary, I think, is the standard. Close enough.
That part of it, so that part I understand, but I'm mainly concerned with giving some integrity to the citizens of the Architectural Review Commission who, heard and prepared a report, and now you're saying that it's terribly deficient and ought to be ignored and sent back.
Right.
That's the thing that,
Well,
I don't know that the zoning bylaw ever expected that kind of result, but that's what you're asking us, and you may be right.
I am asking that, and if I may speak, and I know the chairman of the ARC is here in the audience, my argument has nothing to do with the integrity and the good faith that the board members exercised in the process. I mean, like all volunteers, they sat there, they heard the evidence, they allowed each party to present as much evidence as they wanted. It was a very cordial, polite proceeding. But this is a very significant matter. I mean, the Snows Home and Garden Center is proposing a 7,500 square foot warehouse in my client's backyard. And the bylaw says that the committee is supposed to go through those 14 design criteria. The bylaw does require them to make specific, that's the word, specific written findings so that the decision can be reviewed. And as I argued in my earlier presentation, it's not only for someone in your position now to look down and review this decision for its propriety, but also it requires the board to go through those criteria. I'll concede not every single one, but to go through the 14 of them and think about each one and then weigh and balance them and come out with a decision. As I said, it kind of creates discipline and rigor in the decision-making process. And that's where I think, with all due respect to the committee, it kind of fell apart because they talked about things like Mr. Snow's business is good for the community. That's not one of the criteria. With all due respect to the committee, one of the members talked about the historic provisions of the Cape Cod Commission Act and not the 14 design criteria that the people of Orleans put into their bylaw. And so my argument is twofold, as I said earlier. It is insufficient for this board to review because the findings are not articulated specifically and in relation to the design criteria. And secondly, it's deficient in the fact that they didn't go through the 14 criteria.
And you're not, and your position is you're not going to allow the zoning board to do that, even though we're quite well equipped to make findings on any number of items which are set forth in the zoning bylaw, specifically the special permitting items, which you're going to talk about eventually.
But I thought what we came to kind of some consensus was if you sit in the capacity of the Superior Court of the Land Court, you exercise de novo review. Because let's assume for a moment that the findings were specific, but we disagreed with them. Then you could review those. You'd have to find facts. You'd have to look at this warehouse. You'd have to talk about its dimensions, about its fenestration and its size and its scale, and then you would have to compare your decision, your fact finding, with what the decision says and determine if it's proper or not.
You can't do, but you're not allowing, your position is you're not allowing us to take evidence tonight to.
I'm sorry, I didn't say that.
To review and make specific findings on those 14 elements that the Architectural Review Commission might have done more artfully.
I see where you came to that conclusion when I said administrative review. I didn't mean certiorari or Chapter 30A. I meant zoning administrative review, because if you think about it, we're here like an enforcement, where it's like Chapter 40, Section 7, 8, and 15. That's what I meant by administrative review. I do believe this board can find facts and then compare them to the decision.
Well, see, most of the people in this room and know, certainly the board knows, that generally speaking, our practice has been that the Zoning Board of Appeals was the last stop before a building permit.
Mm-hmm.
It appears that Snow's has squarely presented that in the next numbered application.
Right.
You got here first, and you're entitled, and that's why we could deal with this particular appeal. But you might you might have a remand for, I'm trying to join as a practical matter. And municipal administration, I'm looking for the zoning board of appeals to wrap up all the disputes in some way tonight. We can't do that with your appeal, the way it is.
I would agree, and I think it is a very important point that you raised, because when you get to the next hearing, the applicant has taken the position that it has ARC approval. And it's made that a part of its presentation, that the building fits in because ARC said it does.
Oh, see, but we're not bound by that.
Agreed.
See, that's the.
But I also-
That's the difference.
Right, but it's one of the reasons why we're here.
Yeah. All right. Does any member of the board have any questions of the applicant?
Just one, yeah, I have one. I don't want to get ahead of the situation. So as it stands right now, sir, you would like this sent back in the 14 points addressed in writing?
Yes, and just to make another nuanced point regarding that, I'm not standing on procedure saying, gotcha, you didn't follow the
I know
bylaw."
that. I
Right.
understand that.
My argument is if they rigorously went through each one and discussed each one in the order, I contend they would have come out with a different decision.
And if they did that, if they do that, which you're hoping they will, we will have more facts on which to base our opinion on the next step.
Yes, and I suppose to play it out, and I'm sure Mr. Singer's going to disagree with just about everything I'm saying, but if it went back, and if I were right that by going through those criteria and when they got to things like massing and scale, they decided, you know what, this is just too big, it doesn't fit in, then what would happen is the applicant would have to reconsider and either decide not to build a building or to downsize it. And then when they came back for the special permit, like they're going to be before you in a few minutes, it would be a different project.
I got you. I understand.
Well,
Thank you.
and there's a third reason too, that you get a much better record depending on whatever happened.
Exactly.
And something, that if you didn't get what you wanted somewhere along the line, you had a good record to say that we or the applicant, or both of us, were all wrong.
A very excellent point, and I can make a very specific factual point on that one. Attorney Singer and I had a little bit of a disagreement over what does the surrounding area mean? And Mr. Singer took the position that it was the immediately surrounding buildings, and I took the position that it was the surrounding vicinity, the neighborhood. And there's no finding on what the board felt, because I think if you, depending on which way you view the relevant circle to draw, to compare it to, you might come out with a different answer, because the buildings in the immediate vicinity are a little bit bigger. When you go another property or two, they get a lot smaller.
Fine, and not to anticipate, but that question is gonna be, it'll be before us, before the zoning board somewhere, and what do we consider a neighborhood to be?
Agreed, but my point is when you're reviewing the ARC's decision, we don't know what they felt on that
No,
point, because
no.
they didn't tell us.
No, we do not know.
Right,
Not from, this is all we have.
right.
Any further questions before we ask for other comments from?
Yeah, this may be inappropriate, but not being an expert on administrative law, are you really seeking two bites at the apple here tonight? In other words, if you were not to prevail on your application, are you prepared to go forward and go through the four elements in their application? So you're getting two bites. You get first a sort of a procedural bite, and then secondly a substantive bite?
Yes. Yeah, that's what we lawyers call arguing in the alternative. So, right, my contention is, as Mr. Marnick has very carefully taken my words and put them back to me,
Right.
it's procedurally insufficient. But if the board were to determine or disagree with me, then I contend on the merits, the decision should have come out the other way.
And you'll be presenting that in their application?
No, I'm presenting that right now. I made that argument about fenestration, size, massing. If the board reaches the decision on the merits, my contention is that this building is too big and out of place with the neighborhood that it's in.
You know, bear in mind, sir, that we could give you the relief that you wanted, allow the architectural review commission to to make findings or take further evidence, and we could still, this board could still proceed to the next numbered case tonight. That could happen. Our practice has been that we're the last stop before the building permit, but there's nothing in the zoning bylaw that requires that result.
I understand, and that's a question the board will have to wrestle with.
Yep.
You know what my position is. My position is that it should go back to the ARC. It should be revisited. They should go through those criteria, and the board should not act on the other application tonight, not so much as incomplete, but because it doesn't have sufficient information in the sense that you don't have a final decision on the ARC matter.
Very
But
well.
if the other matter does go forward, we are obviously here to discuss some ideas about that too.
I understand. Do you have any questions?
No questions.
Do you?
Well, you're saying this is a residential zone, this is general business, and the condominiums are in the general business zone, and it's residential use. But, I mean, when you look at some of these buildings, I mean, you got the cable company, and you've got Snow's, you've got law offices, you got some very substantial businesses and large-sized buildings. I guess the way I looked at it, it sounded like they were gonna bend over backwards to screen this from view, make it look aesthetically appealing. You're 77 feet away from the property line. So are they concerned about noise, or?
Well, I think we're going to get into that in the next hearing if we get there. The concerns with regard to the ARC were its appearance. And our contention is that, yes, it is a general business district, but the area where the proposed project is sited is in fact residential, the way it's been developed. There is that Comcast building, but I think if you look at it, it's in one of these photos. It's commercial use, but it fits in, it's relatively small, it's set way back.
Well, and then you have Latanzi's office building, and that's set way back, so I
Yep.
mean,
But Latanzi's building is built very much in a historic type of architecture. And I think it's also very important to understand, and this is the contention I was talking about the neighborhood, when you go down Main Street and then you take a right onto Locust, everything changes.
right.
I'm not an Orleans resident, but I live in Brewster, so I'm very familiar with the area. You know, the main strip, when you go through town, when you get to the Landho and you keep going, once you get to the Brewster town line and there's the cement factory and the car detailing place and Shaw's, that you're in a commercial zone. And that remains that way until you get to the Eastham Rotary. And similarly, the cross street is like that too, from the church, the library, Friends, Marketplace, until you get to Mid-Cape Center and pretty much Latanzi. And then it turns residential. And when you get down to that point and you turn right on Locust and you go down that street, except for the Comcast, it's residential.
But
Now,
this-
it's all GB district. I'm not saying there's anything wrong or with the fact that they're trying to propose a commercial use in a GB district, but the fact is, when you look at the ARC criteria, it doesn't talk about zoning. It talks about surrounding buildings. And when you look at the surrounding buildings, you're looking at single-family residential properties. You're looking at the condominium, which is a bigger building. I'll grant the applicant that. But when you look at the condo building, the architect offset the units, and there's a lot of architectural variety to the building to make it appear like a residential house.
They did a nice job of developing the area. I guess
Right.
I look at this being tucked in back, it's nowhere near Locust Road. Am I missing something?
The one thing, I see where you're going with that. The one thing that is missing, it's in my client's backyard. And I'm sure I'm going to be called a NIMBY, but I don't care, because that's what this is about.
Right.
It's about preserving property values, and my clients are right there. So yeah, it's tucked in the back. It's away from Main Street. It's away from most of Locust Street, except it's right where my clients' properties are. 50 condo units are adjacent to this.
Any further questions? Is there anyone else wishing to speak in favor of the appeal? Yes, ma'am? Is,
I retract that statement.
is there anyone wishing to speak in opposition to this appeal? Chair recognizes Joy Cummings.
This is Deborah Oaks. We're both members of the Architectural Review Committee who sat on the committee the 3 times that the applicant, Mr. Snow, presented his case.
I'm sorry, I missed your names. Sorry.
Oh, sorry, Joy Cumming. I'm the chairman of the Architectural Review Committee, and this is Deborah Oaks.
Okay, thanks.
We heard the applicant 3 times, once in a preliminary presentation to get a sense of what it was that the applicant was presenting to us. And when they came back for their final hearing, they had reduced the size of the building, number 1. And members of the abutting property were there to object to what was being proposed. So we listened to the public comment about their concerns, and we evaluated it, the project, each of us using the 14 points, because that's the way we steer our decisions. But in this instance, it's a storage building at the back of the Snow's property. An example of it is immediately across Main Street. There's Midcape Home Center with a variety of storage buildings behind. The pitched roof actually minimizes the height of the building, which was one of the abutters' concerns. And the applicant was willing to make efforts to contextualize the building by shingling it on the side of the building and in any of the facades that would be in any way visible. And then, upon our recommendation, proceeded to hire a landscape architect who did significant planting around the building along the abutters' boundary, and also put up a site pole so we could get a sense of the height of the building. We all went to the site, we walked it, and then we walked on the abutters' property and evaluated it from every location. And we determined that what they were proposing was certainly something that we could stand behind. So would you like to speak at all about
Yeah,
the bylaw?
the only additional thing I want to raise, which is a question that doesn't appear to be addressed in the bylaw, is how to treat appurtenance buildings, accessory buildings, which are located actually behind the main building, where the property line, does abut, and whether or not and how the design criteria applies to non-public viewing of the building. Primarily, I think the expectation is that the Architectural Review Committee looks at architecture that is visible along the streetway and to the public. In this particular case, while the backside of the property does abut, he says, the condominium complex, and technically yes, but they're actually 2 units that are off a private way. There's nothing public about it. And you can't really see anything unless you're on the 2nd floor of these 2 condos. And we're only saying that because they told us that. We actually asked for photographs, but never got any. So we don't even know for sure that you're going to be able to see anything. So you're always going to have this tension, right, at an edge between one form of development and another form of development. When we review buildings generally, we have not looked at the back of the building, for example. If it's not visible from the street, we don't really pay any attention to what it looks like. And maybe that's because so far it hasn't come up where there's been somebody located behind it to state a complaint. But I don't know how you would deal with that. And just one other thing, Joy, I just wanted to say that we have in the past dealt with accessory buildings, however. For example, as I was driving yesterday were reminded by the police station, which we reviewed, extensively and approved the garage, which is pretty similar to this building in terms of, the building materials, and it's a garage, so there are no windows, there's no balancing of doors and windows, and, trying to make it look like a house. It's not a house, it's a storage building. And it too is located with adjoining visible residential houses, people who live in the area, plus it's visible from the street. So in some way, as I said, I bring this as a question. This is what has been done in the past, the recent past, and then the more distant past with the Mid-Cape, which is across the street from the primary building that we're looking at, which is Snow's. And then the buildings behind, and behind that are other residences also that are buffered with landscaping. I don't know, so we have precedent in the community for this kind of accessory building, for the design criteria to be applied in a way which is, the best you can do a storage unit, a large storage space. But that's quite different than applying design criteria to something that fronts on Main Street and is going to be a restaurant or an apartment building or whatever else we're looking at.
From your testimony, we may conclude that the review of the Architectural Review Committee was quite thorough. You've said that there were 3 hearings and conferences between the Oaks and the Snows, and that we also know that there is in 164-33-1, there is a preliminary statement as to the purpose of having architectural review, and also a further detailed statement of the purpose. And in your enabling, we understand that the town created a 5-person committee composed of people who had specific experience, maybe not like the zoning board where we have a cross-section of occupations or non-occupations. You folks have experience in design elements. That's wonderful. What the objectors to your result have appealed from the report, and that's the problem we may have. And you might want to talk about this. I've tried to interpret it. I think that we might conclude that the words under findings, I can see that they deal with 5 or 6 or so of, if you look real hard at the design criteria, but they're not findings in the way that, say, other boards, such as the zoning board, would make, which is based on evidence that you have come to a particular conclusion, especially you, Ms. Oaks, when you say how you struggled with an accessory building. Finally, you made a conclusion and decided to approve this.
Correct.
How does the zoning board review your decision if we don't have specific findings? That's what I'm asking you to help me out. And whether if the findings, whether you took more evidence, or if we sent this back to you, whether you would be able to prepare a report. You have a form here, the single piece of paper called a report, it's a decision from which the folks at the Oaks say that you could have, at the very outset, they say you could have done a better job with finding, so that it could demonstrate that you did give some thought to each and every, if not all, but the bulk of the design criteria, so that someone else picking it up, like the zoning board, would be able to say, these folks did consider that, and we'll hear more evidence on it, and we can determine whether that was generally correct.
Understood.
That's the problem,
I see.
Madam Chair.
Thank you.
Do you have a suggestion for how we might be able to deal with this? No one is saying you did an improper job.
Believe me, we're
I
not.
didn't hear any testimony that you didn't discharge your duty as you're supposed to under the zoning bylaw, except that the report might have been a little more more detailed to help us and help out the people who are objecting to it. Maybe even helping out the people who got what they wanted from going to you.
Well,
We've been trying.
yes.
I mean, as you see, this is the first time this has come up, and while our committee, yes, is primarily made up of architects and designers, I'm also an attorney, and we've been working at taking the historical processes and procedures of this committee and trying to rework them with town council and get a better sense of
The mandate.
the mandate. And this is something that's been in process. Apparently, historically, or for a very long time, it hasn't been an issue.
No.
But now it is an issue.
No, well, if you look at it, Ms. Oaks, from a land use planning point of view, in a very broad and general sense, you folks have expertise that even the planning board and the zoning board don't have, the other boards don't have. So the deference ought to be given, and we may conclude that the zoning bylaw is constructed in such a fashion to do that, and in all the applications we've seen where the architectural review committee has had its fine hand on it, there's never been a question. We got one tonight.
Right.
And now we have a problem with the report.
Right.
That's,
Right, and
and this
I
is
guess
not-
to be, I think the form that we use and the method of writing our final reports, while it works 99% of the time, because it's done as the hearing is happening, is not sufficient in more complicated cases, and we need a much better procedure.
Very well. Thank you. Is the,
Agree.
thank you.
Right?
Is there
Right, we
anyone
know.
else? Is there anyone else wishing to speak in commentary to this application? To this appeal, I should say. Yes, sir.
Thank you, Mr. Chairman. For the record, my name is Andrew Singer. I'm the attorney for the applicant. And just going to limit to just the process, just to support what the chair said from the ARC. In the materials that I submitted to the committee, which are similar to the materials I submitted to you for the next hearing, I did go through the 14 criteria point by point, and they did review them. Whether or not the decision, maybe needs to be beefed up is a process question, but they absolutely did review everything. We have boards that we're going to show you for the next hearing. I'm not going to bring them up because I don't want to hit you with substance right now. Obviously, from a zoning point of view, you look at a slightly different standard than the Architectural Review Committee is looking at. But I would like to echo what the committee chair and Ms. Oaks said, that the architectural review provisions, which are in the zoning bylaws, they're actually a part of the zoning bylaw adopted by the town. They're looking at the appearance of the town, the historical context of the town. And so when you get to the substance, which again I won't get into in detail right now, but hopefully will in a few minutes, everything they were saying I echo, naturally, 'cause you know, a lot of materials that we had submitted to them and to you. And I do believe that when you go through the 14 criteria as they did, that is where their report was germinated and generated from. Whether or not it can be beefed up again, that's a different story. But I did just want to echo that on process only. I won't, and we can see where you want to go on the appeal and then on the following case.
Very well. Well, the evidence was that you were with the Architectural Review Committee on 3 different occasions. I heard evidence that at least on one occasion, there were further adjustments and compromises reached on the building plan.
Several times on landscaping and building plans, yes.
Have those compromise efforts pretty much concluded? Have they come to an end? Or is further hearings before the Architectural Review Committee likely to result in a project which would meet the objections of those who are here to?
Speaking just for myself,
Yes.
I believe, you know, in the file that the Architecture Review Committee has on this is probably thicker than almost any file they've ever had because we were submitting so many materials. And when you look at the landscape plan and the aerials, which you have reduced copies of in your file for the next hearing, we had tried to, Mr. Snow had reached out to the neighbors, I talked to Mr. Wall, there was another attorney involved as well. I believe that the applicant has done as much as you can do to fenestrate and minimize the scale of this building that's in the woods and to screen it with the additional screening. Not to say we're not happy to talk, but I don't think any further evidence would be necessary. I think the
All right.
committee has plenty of information upon which to write a more detailed decision. Certainly we can go before them if that was their wish, you know. But I do believe that they have sufficient information and testimony and evidence in the plans, the same things you have, actually.
Very well.
Thank you.
Thank you, sir. Is there anyone else wishing to speak yes, sir?
I'm not on 4, I'm on the other side. My name is Jim Aaron, I'm on the board of directors and trustees of the Oaks.
Yes, sir.
I just think there's a little bit of misunderstanding on your part. We have never met with Mr. Snow collectively as a board. To his credit, he has made suggestions in front of the ARC to put the shingles. He's never met with us. I met with him individually when we first heard about it. The rest of our board has never met. He's never proposed anything to us collectively or individually. I just think you should know that, because it's not a matter of consensus building or further work, as you just mentioned, because there hasn't been any. He has, at different times when these ARC hearings were going on, he has proposed doing the shingling at one time, excuse me, making lights that go down, and there was something, more screening on the side, but that was at his own motivation. He has not come to us to ask us what we want to see.
Very well. I understand.
Were you present at the ARC hearings?
We were
Okay.
2 of the 3.
Mr. Chair,
Yes, sir.
I'm not familiar with this board. You haven't seen my face before. I'm not going to go point for point, but may I make one minor point?
Of course you may.
I yield the floor. Back to the point of the findings about why they're so important, and I give utmost respect to the chair and the person, the other member of the committee, but actually, review of the bylaw tells you what it's applicable to, and it's section 164.33.1C, and it talks about applicability. It's a big, long paragraph. I won't read the whole thing, but the bylaw makes it very clear that the review process applies to all building permit and special permit applications, and then it lists a few exceptions. One of the exceptions is accessory structures to 1- and 2-family dwellings, not to commercial properties. It also talks about properties that are in the Old Kings Highway, and I can tell you I've had some experience with that agency as well. There is language in their enabling act that says that they review things that are able to be viewed from ways, not only public ways, but private ways. There's no such language in this bylaw. This bylaw applies to all building permit applications and special permit applications unless specifically excluded. And this building is not excluded. And I'm not making the point to argue with the member that just spoke. But it goes to my point about the findings, because had that been articulated, then this board could then say the ARC correctly applied the criteria, or maybe the board could say the ARC did not correctly. But we don't know from the decision as it's written.
Very well. Thank you, sir. Yes, Mr. Steiner?
Just one point as you're considering this, because this, obviously you're looking closely at the bylaw. If you also look at section 164.33.1E, which are the design, those are the 14 design criteria, it states that the following criteria shall be used as a guide for the Architectural Review Committee when reviewing applications. No project shall be approved unless the Architectural Committee finds that it meets the overall intent of the design criteria described in the bylaw. So what the committee is looking at is not necessarily, these are guides that they're looking at. These are not a holy grail of you have to meet each and every one of them. They're looking at the overall intent of the design criteria. And I think you could find, if you wanted to, that the language they have in their report and the findings does reflect the fact that they're looking at the overall intent. You have to go through all of them, character, scale, massing, everything that Attorney Wall mentioned to you. But when you look at those as a guide, that's what the committee is actually doing. It's not that the 14 findings are things you absolutely have to have, but it's things that you're supposed to look at to generate a review as to, and he talked about the applicability section of the bylaw, but if you go back to the very beginning of it, the purpose and intent of the bylaw, which is to look at the architectural styles of the eras and its later 20th century buildings and character of a desirable community for summer visitors and year-round residents alike, and it talks about business and other things. So that's what you're looking at again, or that's what, I'm sorry, that's what they are looking at when they're reviewing a project.
Yes.
Thank you.
I think I understood, Mr. Singer, that Mr. Wall was not saying that the 14 characters, the 14 criteria were subject to scoring, but he does bear in mind also that the final plan review and report has to be based on consideration of the design criteria. And I know that they're looking at it as a whole, but also that the report shall state in all cases the committee's decision to approve with modifications, or disapprove of the plan, and shall contain specific written findings relating to compliance with the design criteria. Mr. Wall gave up tonight the fact that all 14 had to be dealt with, but I think we all understand that a holistic approach was something that the ARC was always dealing with, and Mr. Wall has given honor to that. He only says that in the final analysis, the plan review report dated August 24th, 17, didn't have enough, maybe not any findings that were identifiable or at least would qualify under 164.33.1D4. I'll close the, if there's no further remarks, I'm going to close the application of the appeal for hearing and ask the discussion and from the members of the board. I've done most of the speaking tonight, members of the board. I'm thinking that, and we've heard from the Architectural Review Committee, a dedicated group who we honor time and time again in the town and before this board, but the applicant says that the report ought to have been more specific, and I think that that's correct.
Mr. Chair, if I could.
Yes.
So, looking at the record, the subject property has gone through a very rigorous process to this point. I heard 3 visits to the Architectural Review Committee. I see Conservation Commission approval, Site Plan Review Committee, and now tonight, Zoning Board of Appeals, not to mention Cape Cod Commission. What I think the current applicant's argument was lacking was in substance related to concessions or design tweaks or improvements that they wanted. I didn't hear a lot of substance on that point. I didn't hear any rejection of any of those suggestions from the subject property representatives. I don't think that the town or the process would be served by sending this back to a fourth review of the Architectural Review Committee. I'd be inclined to recommend that we move forward, hear from the applicant, invite the current petitioner to participate and comment on that application, and as we normally do, take into consideration that feedback and see if we might come away with a solution that works.
Fine, Mr. Cole. My thinking was that we were going to proceed with the next hearing, even though our practice has generally been that all preliminary hearings and boards would have been here. But in this case, assuming that the applicant's ready in the next numbered case, we can go ahead and proceed with that. Maybe giving some further guidance in our whatever findings that we may make in that to the Architectural Review Committee when they take a look at it again.
I'm inclined to not remand it to the Architectural Review Committee, but I speak only for myself.
Very well. Mr. Mulligan.
Yeah, I side with Matt. This raises one of the issues that concerns me since I've been on this board. But first, let me comment on the presentation by the two members of the board. I was very impressed with the thoughtfulness. The decision doesn't give us evidence of the thoroughness, but I'm certain with the thoughtfulness that was articulated in the few points they mentioned, I'm sure the thoroughness was there too. As I was sitting there, I'm loath to put myself to replace their judgment. People who have given great thought and articulated well the concerns they had. Obviously, they labored over. There's no guidance in the bylaw about appurtenance buildings. I was sitting there saying all these things that they're worried about, I'd be worried about too. And I'm certain that I would bring no wisdom or value to that it wasn't fully explored and understood at the hearing. So, but my greater point is that sitting here, when we have issues like this from time to time, I'm concerned about the whole issue of a citizens committee. I think we get these issues where, to me, I think the process was the 3 meetings, it was probably thorough, met all the requirements of the bylaw, but there's a piece of paper that doesn't. It wasn't, to me, if we remand this back to the Architectural Commission, we might as well say we all have to be lawyers to sit on these committees. You have to be practicing law. These are tribunals. This isn't a citizen committee bringing the wisdom and goodwill of the community to think about how we govern ourselves and how we. So I think it's a very important point that if we send this back without any real evidence that the hearing wasn't fully thoughtful and thorough, except that there's one piece of paper, then we're putting form over substance, and we're putting legalisms over practical application of running this town with citizen committees. I feel very strongly that we should deny the petitioner's.
Your comments and those of Mr. Cole are quite persuasive. Peter, do you have a?
Yeah, I was just thinking about some things here. I was thinking, Ms. Oakes said that it wasn't visible. Well, she said in the past, if things weren't visible from the street, we didn't pay much attention to it. I think that that point about private ways brought up by Mr. Wall was significant insofar as the Oakes people have rights too as taxpayers, even though it's not visible from Main Street. So I think that the Oakes people have a very strong right to appeal this. The police station and Mid-Cape were mentioned as similar things where they had large buildings abutting private dwellings. Well, no appeals were filed. I sat on the police station review and there were no appeals like this. I wasn't around for Mid-Cape. And Mr. Singer said that he thought that the intent of the criteria were met in the brief summary that we do have. I don't agree. I don't think they were. in summary, I would say that this community has been very good to Snow's, and I think Snow's can and should be good to this community, and this should be processed rigorously in writing regards the 14 criteria. Because it's very important. This is a very important case, in my opinion, for this town. And so I would say that it should be sent back to let them put what they feel in writing. They've had lots of time to ruminate over this. They should readily come up with the answers that fit in the 14. Because, as the chair said, they've been over and over this. I also, I don't know if this is the time to say it, but this is the way, I don't think we should go forward with the second hearing until we have all the facts.
Very well, and, I'm thinking that maybe in the second hearing, we're gonna hear a good deal of evidence concerning which has already been heard by the Architectural Review Committee, or would be heard if we send it back. So I'm starting to have a second thought. Beth?
Having served on the first Architectural Review Committee that Orleans had and reviewing Snow Library, I feel for what you're going through. You're here doing what you think is good for the town, and it goes askew. I agree with everything Matt said. I think they've done their job. I think we need to see if we can work out something between everybody that's here tonight.
Very well, then, is there a motion to deny the appeal from the decision of the Architectural Review Committee?
I'll make that motion.
Is there a second?
Second.
Any discussion on the motion? All those in favor?
Aye.
And opposed?
Nay.
The motion carries 4-1. Very well. Case number 2074, the application of SSJ Real Estate Holdings LLC for a special permit as set forth in General Laws, Chapter 48, Section 6, under Orleans zoning bylaw sections 164-3C, 164-13, 164-21, 164-34, and 164-38 to change, extend, or alter a pre-existing use and construct a new accessory commercial building. This property is located at 22 Main Street, Orleans, map number 25, parcel number 59. Those following regular members of the Zoning Board of Appeals and Mr. Mulligan will consider this. I ask whether any member of the Zoning Board has had any communication with the applicant or any of the applicant's agents concerning this application, which ought to be disclosed to the public, to constitute a conflict of interest. There's no positive response, therefore I declare that the members of the Zoning Board are impartial and indifferent. For the record, I will write the opinion on case number 2073. Mr. Singer.
Good evening. Excuse me. For the record again, Andrew Singer, attorney on behalf of the applicant. With me at the table is Sid Snow from Snow's. With us in the audience is Dave McNevich from Coastal Engineering. I've set up a couple easels here for Mr. Mulligan and Mr. Llewellyn. If you cannot see it, please let me know. It's hard to do with a table. These are copies of things you should have in your file, but they're a little bit bigger. And I had submitted a summary of reasoning to you, which will be the framework for the presentation. We appreciate your continued review of this proposal and specifically through this particular hearing. Some of this may be a little bit redundant, and I apologize for that, but given the nature of the hearing you just had, that can't be completely avoided. The Snow's property, which is, on the aerial starts off the bottom actually on the lower left and then wraps around in that L shape. We have shown on there in a red outline where the proposed building is. And again, you should have a smaller copy of this in the packet for you to see. The property is located in both the VC and the GB districts. The VC portion, Village Commercial, is actually closer to Main Street, and then the back part is all in the general business zone. The property is improved with Snow's Home and Garden Center, which has their retail store and garden center, the fuel storage and delivery business, and it's been the site of the Snow family business since the early 20th century. It's been on this property for more than 100 years. The building that is being proposed is 7,400 square feet in area. It is, however, a one-story building, and it is only 24 feet 8 inches high. Some of the information you heard in the last hearing was off a little bit. So it is a one-story building, and it's going to be used to store retail product, dry storage of retail product. This area has been the area of the outside nursery stock storage for the business. The building itself is not going to have water. It's not going to have plumbing. It is going to have electric service, and that's it. So it is not meant to be any sort of, for any sort of hazardous materials or liquid materials. It's retail product. And the retail product, as I wrote, is principally charcoal and gas grills, furniture, teak and otherwise, seasonal fixtures, and Christmas merchandise. So it's dry, it's retail product that Mr. Snow sells in the store today. Right now it's off-site and has to be trucked in all the time. This allows him to actually store it on the property. I won't go into too much detail about the back. I did write about it at length, but the fact that part of this area, the whole area was in different types of conservation restriction at one point. This part, which is the nursery stock area, was the area that has been released from that after a public review with not only the Conservation Commission and the selectmen in town, but also the town meeting. Town meeting voted on it, as well as the Cape Cod Commission and the Massachusetts, not only the Executive Office of Environmental Affairs, but also the Mass Legislature. So everybody was involved in that initial part of the process, which took place during and at the end of 2016. And so now what we're before you is the request to place this building in that part of the property to allow it to have this storage. And as was written before, but again, for the record, Mr. Chairman, on this particular case, we have been and obtained approval from the Site Plan Review Committee, the Architectural Review Committee. We have been before the Cape Cod Commission, and they have reviewed and approved the request. That a minor modification was required from their decision back in the 1999-2000 was the decision, because the property was under the DRI originally. Even though this building is under their jurisdictional limits, it's not a 10,000 square foot building, we did go back because there was a decision, and we did obtain that modification. So for a moment, this is the large copy of the site plan itself. I just wanted to point out there is a wetland to the south. You're familiar with the property. The bike path runs along the bottom off this plan, and then there is a wetland there. The building is well more than 100 feet from the wetland, but there's a piece of the driveway that will nick jurisdiction, so that they will be going for an RDA, request for determination of applicability review, for that part of it. We're here before you tonight for a special permit. And it's a special permit to alter pre-existing non-conforming conditions and to allow a new building that has more than 2,500 square feet of gross space in commercial use. This is not a building for customers, but it is as an accessory building it's a commercial accessory building. It does trigger that review. The standard you look at is, will the proposal, what is before you, with everything we're gonna lay out for you, will it be substantially more detrimental to the neighborhood than the existing non-conforming conditions in the existing area that it is in? You are looking at it under the zoning bylaw to determine if it will be detrimental to the established or future character of the commercially zoned neighborhood in the town, and whether it will be in harmony with the general purpose and intent of the zoning bylaw. And finally, you're looking at if the benefits outweigh the detriments of the proposal. For a number of reasons, the applicant respectfully submits that the proposal will not be substantially more detrimental to the neighborhood or the town, and that all of the desired relief can be granted in compliance with all of those other provisions that I just mentioned. And the principal reasons for that are, the accessory building is part of a permitted commercial use in the commercial zoning district. And the overall use of the property is surrounded by commercially zoned land, and as I mentioned, have been in such use for more than 100 years. The accessory building will be in the rear of the property. It's going to be surrounded still by significant conservation restricted wooded open space. And the additional screening, if I could, sorry for getting up and down on you. What was discussed during prior reviews, Mr. Snow has been in all the meetings, and he has worked with a landscape architect, and the intent was to minimize the appearance of the building and provide additional screening for the Oaks community. Mr. Snow has worked with the neighbor as well, who's on the other side of the building, and who owns the property with these two structures in it. And that, I understand that neighbor, with the work that Mr. Snow agreed to, has been accepting of the proposal. He has not been coming to the meetings, but Mr. Snow has talked with him and also provided this. As you will note, the doors, as you can see, are going to be on the south side for access, so there is an emergency door and a fire lane, but there's really not other access on the other sides of the building. So the activity at the building is going to be on the south side, which means it's going to be away from the Oaks property. It's going to be towards the main Snow's business portion of the property. That's where the activity will be taking place, as opposed to now it can take place all around the outside. It's going to be coming in from that side. As part of the prior reviews, Mr. Snow, through his landscape architect, agreed to plant the additional screening this is the building, this is the nearest building on the Oaks property. So they are at a little bit of a lower grade there. This is existing vegetation. This is the new vegetation. I just wanted to point out to you that Mr. Snow had proposed, and it's right here. It's in this staggered. It's not a full line, or it's not a straight line. Our landscape architect, unfortunately, could not be here this evening, but it was done staggered as a way to improve the screening and to make it more year-round in nature. And Mr. Snow has agreed to plant those full height at the time of planting. So they're going to be 8 to 14 feet tall. Those are all listed on the plan, and you have a copy of that. So he's proposing, as opposed to, a lot of times people will propose trees, and they might be really, really little when they're planted. They don't really provide immediate screening. These are going to be 8 to 14 feet. There's 8, 12, and 14, I think, are the three different heights of the plantings. They're going to provide immediate screening for the building. Also, what's been proposed are enhanced setbacks. The zoning bylaw only requires a 10-foot setback. This is the general business zone. Lots of commercial activity could take place around in this part of the property, and you only need 10 feet of buffer. Well, what Mr. Snow is proposing, in addition to the fact that this land here and well off the plan to the top is still part of the conservation restriction, he's proposing 43-foot setbacks from the westerly property line, 77 feet from the easterly, which is the Oak side, 291 feet from the northerly property line, and 353 feet from the southerly property line. So thus, you can see on this plan, this is the area that's 353. This is the area that is 291. And so there is going to be very significant, not only is it going to be very significant buffers from a physical point of view, but the land between the building and the various buffers is part of the conservation restriction. The applicant would respectfully further submit that there's going to be no noise, odor, litter, or other sources of potential nuisance or inconvenience to the adjoining properties, the public ways, or the neighbors. The lighting is going to be low-level shielded lighting. It was designed to meet both the Cape Cod Commission and the Town of Orleans bylaws. There are 7 lights, and those are on the plans. There's 2 on either, there are going to be 2 on either side of the building on either side, and then there is going to be 1 in the back and 3 here, one of which is going to be at the person door. So it's a light just at the person door there. Excuse me. In addition, Mr. Snow offered a couple of additional limitations, or one thing he did this past summer, which was something that was discussed at the Architectural Review Committee with the neighbors in the room, was he transitioned his forklifts to use a white sound noiseless backup alarm. It's a system, and we provided his information for it on the websites, where you can actually hear it. It's more of a whooshing sound, and it's very targeted, and it's lower. And so he's not using the annoying beep, 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 the backup alarms. He got rid of those earlier this summer. So even notwithstanding not having approval or even being before you yet, he went that step to try to be a good neighbor. That is something he's tried to do with everything he's done, through the changes in the building, the landscaping, and the alarms, to try to be a good neighbor on the neighborhood. He's also proposing a further limitation and restriction that we would ask you to include as a condition in any approval, which is that he's proposing restrictions on deliveries to this building being limited to Monday through Friday, 7:30 a.m. to 6 p.m. And those are much tighter hours than you would normally have in the GB zone. But he's proposing that, again, to try to give assurance to all neighbors that this site will not be accessed with deliveries on the weekends, nor early morning or late at night. He's trying to recognize that even though it is a commercial zone all around, that there are certainly some residents in the area, so he's trying to be respectful of that. We would submit that the building has been designed to meet community character standards. Now, this is where we get to part of an overlap between yourselves and the Architectural Review Committee. And those are the aspects of the fenestration, the siding, and the roof color. Those were all changed through the process, and the architect was at those meetings as well, to minimize the scope. So there's going to be siding. Yes, it's a metal building, but there's going to be siding on the long sides of the building, so that it's going to have not a metal appearance to it. In addition, the roof color was made, and we gave you some samples for it. It's actually a color that the designer noted is less visual in the off-season. So again, when in the winter, when some more of these trees, will be losing some of their leaves and canopy, this roof color that's proposed, that's on the plans, will actually have less of an appearance. It's not going to stick out. So even if you could get a glimpse of the building from a couple of these buildings at the Oaks, that it's not going to be very visible. The whole point of it has been to minimize that color. And the fenestrations on the building have been done as well. Everything done separate from the screening to attempt to blend the building into the surrounding natural scenery. Now, I recognize this is a commercial zone. We're not usually talking about blending buildings into the surrounding natural scenery in the commercial district. But in this case, it's a special area. It's all commercial, but because we have multiple uses, it's a mixed-use area. Our property isn't, but the general area is mixed use. We're attempting to do that. As was noted, building will not be visible from Main Street or from any public places. We would argue that this is the one driveway from the Oaks property that is the closest. It's 80-odd more feet away, or plus their property. But we would argue that when you look at the landscape plan, that area would be approximately here, because that's that lower building. Because of topography and the landscaping, this is the existing canopies and the additional vegetation, we do not believe that, from a zoning point of view, that what is being proposed would be, not only will it not be, we argue, substantially more detrimental to the neighborhood, we would argue that it's not going to be a detriment at all. We believe that it will work well in the neighborhood and in the place where it is proposed on the property. The height at 24 feet 8 inches in a single-story building is well under the maximum height that you see for commercial buildings, and it is significantly below the tree canopy, as you see on the cross-section plan. I won't go in. It's in my summary. I won't go into all of the discuss all of the sizes of the buildings, but we would submit that the scale, mass, and bulk of this accessory building does fit the surrounding area, and Attorney Wall will probably mention it again, as he said last time, that we have a disagreement maybe about what the area is, but I would submit that the area is everything on that plan. So you have commercial buildings. This is Latanzi's office. This is the Comcast building. You do have some houses up here, but a football field or more away from the building. And then you've got 12 to 14 of these large 2.5-story buildings on the Oaks property. And they're in a commercial zone. They have to be, actually, because apartments are not allowed under Orleans zoning in residential zones. They're only allowed in commercial districts. And so when you look at this whole area, and if you come down here, you've got the bike path. Excuse me, and then there's more commercial here. But again, that's, at that point, you're over 400 feet away. I don't think, anybody, that's the area, but I don't think that it has any impact. I suggest that the scale of a one-story building here with a low roof and the fenestrations will be actually better screened and hidden and less of an impact than most of the other buildings in the neighborhood. Excuse me. As far as the mixed nature, and I mentioned that of the area, I think that's important because of how Orleans deals with the GB zone and the LB zone. This area, and so this is this is VC here, this is GB back here, and then LB goes down Locust. So the LB zone is over here. There was actually a planning board process in the late 2000s, 2007 or so, where it was proposed to change the Locust Street properties to residential zone and to make the GB zone an LB zone, so basically try to downzone the area. Through a public process back at that time, it actually didn't go forward. My understanding from the records I've seen is that the output of public comment was that people wanted the zoning to stay the way it was, because there are a lot of mixed uses, some smaller businesses, some larger businesses, some smaller residences, some larger residences. And it was felt that that was an appropriate zoning and way to continue this area. And that's the way it has stayed. It hasn't, in fact, changed. I think it's also important, excuse me, that when we're talking about the apartments, and I'm focusing on them obviously because Mr. Wall is here with the neighbors, the zoning bylaw states, and these condos were built in the late 1980s, from like the late 1980s to the early 1990s. So about 80 years or so after Snow's was already on the property, the condos all went up. The bylaw actually provides, it's a cross provision in the zoning bylaw, and it says that a business on a business property in the business zone cannot or should not harm an adjacent use. However, for the apartment use, and this is specific under the apartment portion of the zoning bylaw, it also says that that use on a business property must not be adverse to the business operations on adjacent properties. So the bylaw incorporates this mixed-use concept. And we would submit, again, for your review and hopefully approval after consideration, that everything we're presenting to you, everything you're going to hear tonight, any questions you might have for us, will demonstrate that what's being proposed will not be substantially more detrimental on the neighborhood or to the adjacent property, but also recognizing that the fact that two of the buildings of the Oaks are closer, the fact that they're there, they can't by themselves be just deemed to be, they can't be averse to having any commercial use on the commercial property. Obviously, you look at that. If we were proposing 3 smaller buildings right, 10 feet from the property line, you might say, okay, you've got the condos there. Could you have a bit of a bigger setback? What we're trying to do is do that. So everything you have before you is an attempt to minimize our impact on them. However, their existence is also under the zoning bylaw not supposed to have an adverse impact on business operations on adjacent properties either. From a transportation point of view, we think this is a significant benefit. Right now, Mr. Snow stores all of this product in various places around town, possibly out of town. I'm not sure if some of them might be in Brewster. What he's going to be able, so they're all being trucked to the property. You have more use of the roadway network. This storage on site is going to reduce transportation impacts on the roadway network. That is a benefit because you will be able to have the trucks come. I believe, for example, he gets his Christmas supplies months early. They can come in, they can stay there, and they're not going to have to continually be restocked to the property. There will be no adverse impacts to surface water quality or groundwater quality. Stormwater management is provided to continue to protect not only the southerly wetland, which is 150 odd feet away, but also to ensure that all runoff is controlled on site. There was a stormwater operations and maintenance plan that was submitted, including a maintenance schedule that has been provided. On-site nitrogen concentration, these are things we provided to the Cape Cod Commission and we also provided to you. On-site nitrogen concentration is actually being reduced and there'll only be a negligible additional nitrogen load to the watershed. So again, the fact that this building has no plumbing has no septic system that is needed, and won't actually have people, staged in it. It's not office storage, office product, or offices for people, I'm sorry. All of that limits the environmental impact as well. There is, in consultation with the Orleans Fire Department, there is a fire lane that has been provided adjacent to the building for them to get to it. There will be, again, no water or plumbing for the building, just the electric service. We would submit that the proposal will not adversely affect the public health, safety, convenience, or general welfare of the town, and that's one of the provisions you look at under the zoning bylaw. To the contrary, we'd suggest that the proposal will actually even better protect these than many of the other uses that you could have. If you look at the zoning bylaw for what's allowed in the general business zone, you have many uses that are much more active, much noisier, much brighter, much more intense on the land. Submit that what's being proposed is actually a pretty light use of this portion of the property, recognizing that the whole thing is GB zoned. Allowing this proposal will allow a long-standing historical business family in the Orleans community to continue to thrive into its third century. Mr. Snow has said that at all of the prior hearings. He may say it tonight in questions and answers. They need to adapt to survive. They've been doing it for 100 years, well, 103 centuries now, or in the third century now, and this will allow them to continue. And they're not asking for an active use. They're asking, again, to store their retail product in the building. For all those reasons, we'd ask you to respectfully make findings that the zoning bylaw provisions have been satisfied, and ask you to grant a special permit to allow the redevelopment with the conditions and limitations that we're proposing. If you have any questions for any of us, we'd be happy to try and answer them, and we appreciate your time and appreciate your review of the project. Thank you.
Thank you, Mr. Singer. Now, I have recently filed, since the application had been filed, a document entitled DRI Minor Modification Type Number 2, dated October 12th.
Correct.
2017, addressed to SSJ Real Estate Holdings from the Cape Cod Commission. And a number of findings, quite detailed, are set forth. The presentation that the applicant made to Cape Cod Commission, did that include the modifications which the applicant made as a result of the 3 hearings before the Architectural Review Committee?
Yes, identical plans. The plans that the Cape Cod Commission reviewed are the plans that the Architectural Review Committee, Site Plan Review Committee, and what we provided to you.
Very well.
Same plans.
I noted, it looked as if that those had been incorporated in the findings of the Cape Cod Commission. Now, there have been no changes then to your proposal since the Cape Cod Commission passed on it.
Correct, no changes.
And the 2 conditions which you offered, that I heard, are not contained in the Cape Cod Commission's modification. One of which was, and maybe you could articulate that in words, concerning the forklifts that operate with white noise. How do you describe that verbally?
You don't like whoosh?
No, I didn't mean that.
I'm not trying to spell it, but
I think that's a great.
to answer your question, Mr. Chairman, in a couple ways. First, those 2 conditions are not in the Cape Cod Commission decision. They were discussed. However, the Cape Cod Commission does not generally like to put in restrictions that would have to be enforced locally. They leave it to the local boards to do it.
That's right.
And so that's why those aren't in there. As far as the backup alarm, I don't know if I had given you this, but I could submit it for the record. This is actually a print-up of the noiseless backup alarm with the decibels and all the specs. This is from the website. And if you, I'd be happy to submit that to you. That hopefully would address your question, Mr. Chair.
Thank you. And therefore, the condition would be that the operation of forklifts would comply with, would be equipped with BBS-tech backup alarms or similar device.
Correct.
Is
And-
that,
Yes, and they already are.
Already
but
are.
That would be fine. Yes, just to ensure, again, so that for the neighbors in particular, to ensure that it would remain. But they are already installed, and they will remain.
Is there gonna be a sprinkler system in the building?
No, there is going to be no plumbing whatsoever. So there is no, and that's one of the reasons why it's dry product as well.
Okay.
the other condition which you mentioned, Mr. Singer, was regarding delivery times.
Yes.
And I'm I could probably type that if I had my iPad here more quickly than I could write it down. So can you repeat that, please?
Deliveries to this building will be limited to Monday through Friday, 7:30 a.m. to 6 o'clock p.m.
7:30 a.m. to 6 o'clock p.m.
Correct, Monday through Friday. To this building, deliveries to the remainder of the property will remain as is, but to the back part of the property, those will be the restrictions.
Deliveries to, what are we calling this?
It is an accessory, it's an accessory commercial building.
Storage building.
It is not a warehouse under zoning. I hear the snickers behind me.
No,
If-
I'm just looking for it.
yeah, it's an
Colloquially,
as-
it's one thing, what it's
Right.
contained.
Under zoning, it's an accessory commercial building.
So delivery to the storage building will be limited to Monday through Friday, the hours 7:30 a.m. to 6 p.m.
That is correct.
Ec-
Yes, sir.
Very well. Do we have questions by any members of the board?
At least one.
Yes, yes.
Okay, Joy mentioned that you put a post up to get a visual from the building, from the condos. Is there anybody that, in the abutting buildings that wanted to address that?
I'll
Jim?
address that, sure. Jim Enright again.
Yes, sir.
The buildings that Mr. Singer alluded to, the only one you just barely see, by the time we got to the third hearing, we're into the spring, all those trees are full of leaves. So you couldn't tell, you couldn't even see from the second floor, which Mr. Singer said he never got a picture of seeing. We couldn't see because the trees were in front of you. In the wintertime, I had the opportunity to stand on Mr. Snow's property, as you invited him to do so, and I could see, not only those two buildings, I could see all the way down that private road, which is not private, the public is allowed access there. And you see most of those condominiums all the way through, because there's no vegetation to speak of in the winter months there. We're talking locust trees for the most part.
Okay.
And, yeah, well, I didn't bring the pictures, but,
We have some pictures, which I think might be the kind,
yeah.
you know, these were, this snow, so.
I went out there in January because I was concerned, trying to be a good neighbor, and
Yeah.
I'll get into that in a minute, but this is sometime in January, and when the vegetation is off the leaves, as you can see, you know, you're gonna be able to see this building, but it's not like I'm 10 feet from the line, and there's limited screening of vegetation.
And you're gonna do like Leland cypress or something?
And
Arborvitae or?
before we get to this natural screening, we're going to, have an extensive plan, which I worked with a landscape architect to give a variety of evergreens and deciduous trees so that it wouldn't look like it was a blanket wall of Leland cypress
Yeah,
that kind of,
okay.
in my opinion, looks kind of ugly.
Yep.
And so that's what we're trying to achieve with this. And it'll have different growing heights and different patterns and.
And this was all, these are the two buildings, so this is that area that Chief Earhart was mentioning, and these are the plantings, and this is the area which is being screened, and just, it's on your plans before the record. They include multi-trunk river birch, white pines, and green giant arborvitaes, and those have been mixed in by the landscape architect, Dave Hawk from Hawk Design. There's a lot of work in the area, and they've been all produced, so there's 22 additional full-size plantings that are going in this area to provide that additional screening.
Are they doing Leland Cypress at all?
No, the Lelands, everyone likes them except the regulators. They are considered a non-native tree, and while I personally like them,
they're horrible.
yeah, so they are not proposed because they were.
Privacy.
Yes, we were asked not to do them.
Okay. No,
So that's why,
That's good to
what
know.
Mr. Hawk did was he tried to come up with alternatives that provide that screening capacity and the survivability, but are something that are more native.
What I tried to do all along is, to listen. And I listened in all the three of the architecture review hearings. They all had a group behind us, and I did what I could. I told them, I said, I'm willing to work with you. Let me know what your concerns are. So the concerns was noise. So in July, I put in the backup beepers. The concerns was that visually they'd be able to see the building. And so I worked with a landscape architect to come up with the screening, and we actually beefed it up more as some requests with the Architectural Review Committee. And I've actually been very careful on siting the building, and due to their request, I've actually sited, I made it smaller, so it was originally going to be 9,200 square feet, so I limited it down to 7,400 square feet. I said that I would put cedar shingles on both sides that face each abutter. We changed the lighting on it to be just enough lighting to barely see to walk to the doors. There'll be no lighting, at floodlighting at all at night. Really won't be anything happening at night. And I actually walked the site with both abutters. Jim very nicely came out with me in the wintertime. We walked the site. They asked me where the building was going to be located, so I told them I let them know when Coastal Engineering had it staked out, and they can come over and take a look at where the stakes are. I put up poles so they could see where the boundaries would be from their condos. I talked with Greg Hartson, and I think he's here tonight, the abutter on the other side. Explained to him exactly what was going on. We walked the site together, and I said I was concerned because there was some areas that would be exposed. There wasn't natural vegetation, and I said I would put up landscaping to protect that. And I think he said not to worry about it. Said he'll put up his own trees or landscaping and take care of that. So I think I've done just about everything I possibly can think of to address the concerns and to make it as soft as it can for them. And it's becoming apparent to me that there isn't anything I'm going to do that's going to make them happy. I've never been thanked for any of the things that I've offered to do, and it's becoming apparent to me that this is becoming a legal issue, because a regulatory and legal issue, because they actually have said publicly that their intent is really not to come to any compromise. Their intent is to stop this building from ever being built.
And so what we're trying to do, which is all we can do, is focus with you on the special permit that we're asking from you and the criteria that you look at, and trying to address those concerns as Mr. Snow has offered through conditions and questions and comments you might have.
Well, it's not the purpose of the board to mediate disputes, but I
No.
think that we've all, the commentary here has been to, in a polite way, to determine whether any compromises can be met. Sometimes those compromises end up in the form of conditions.
And those are some of the ones we've attempted to offer to you this evening. Mr. Chairman?
Yes.
If I could ask, Mr. McNevich from Coastal Engineering, project engineer, could he has one thing he'd like to add about the building, if I could ask him to?
Yes,
Address that?
that's fine.
Sure, so, just, you heard that the building had been reduced, it was 9,600 square feet, down to 74. But one other thing was, originally, the building and filing were swapped. The building was actually going to be over where the filing is, and the filing was on this side of the building. So, in order to try to accommodate some of the concerns of the neighbors, Mr. Snow decided to flip those two and provide another 18 to 20 feet of separation to the oaks. So there has been compromise in terms of positioning the building to try to maximize that buffer.
Very well.
And the one other thing I would just clarify, this paved driveway exists. So Mr. Singer mentioned we have to go to conservation. It's not for construction of the driveway. We're going to conservation for construction of the electric line and clearing on either side of that existing paved driveway to provide the required fire department access. They require a width and a height to be cleared, and that's why we'd be going to conservation.
Mr. Mulligan, do you have any questions?
I do not.
Mr. Jablon?
No.
Mr. Cole?
No.
Ms. Van Giesen? Beth? No. Is there anyone else wishing to speak in favor of this application?
Not in favor, just under clarification from what Mr. Singer said, the direction of the vehicles going in, would not be providing our property. Have you moved the building, the entrance, or is it still at that end?
No.
Through the chair?
Yes, please.
Can I ask that question?
Yeah,
Yes.
the entrances are, the entrances are here on the south side of the building, facing towards the south and Snows. The condos are over here. So, no, Chief, that has not changed.
So that's just the side parallel to the condo, they're coming out that end.
It's not coming out this side,
No,
no.
it's coming out this side.
Correct.
Condos are right here.
Correct, yes.
Okay.
Yeah.
Yeah, you said we wouldn't see them. or anything.
Well, what I said was, they were put on the south side to try to keep the activity as far away from the condos as possible.
Oh.
Yeah.
Right, that's further to what you mentioned, that you'd moved the location of the storage building over for the, reciting the road.
Correct.
Now, is there anyone wishing to speak in opposition to the application?
You want to stand or you want the table?
The pleasure
of the
board. Would you like me to stand as final?
I think you may choose, I think you have the right to sit down.
Now I'm gonna
Thank
make
you.
a stand.
As we age, the hour
have
gets
that when you're
later,
done.
so
Yes.
10 or 15 years ago, it was easier. Okay. So, for the record, my name is Brian Wall. I'm an attorney. I represent the trustees of the Oaks condominium, which is a direct abutter to the proposed project. I did just submit some materials. I apologize for doing that. It's not my style to come into a hearing. In fact, with regard to the last hearing, I had provided Mr. Singer a copy of my appeal at the same time that I filed it with the board. I had an appellate brief that had to go out in the mail yesterday, so I was working on this today. Having said that, my clients, as you know, are in fact opposed to the project, and we have several arguments to present to the board tonight about why the board either cannot or should not grant this permit. And I'd like to start by focusing on what is the relief that's being requested of you. There was a lot of description in the presentation about the building and the physicalities of it, but I think that the basic part of the relief was somewhat glossed over, if I may say so. So my understanding is that there are two separate pieces of relief that are necessary. One is that the building that's being proposed is 7,400 square feet, and any building in this district that's over 2,500 requires a special permit. And then secondly, and this is the part where, and I'm not being facetious, but I'm a little bit confused about exactly what the applicant is proposing, but I've heard it called an accessory commercial building for dry storage. And the chair kind of said, is it a warehouse? And I think that if you look at the definitions in your bylaw, it is. And there is a definition in the definitions section called wholesale business warehouse. And I'll paraphrase, it's a use engaged in storage, wholesale, and distribution of manufactured products, supplies, and equipment, but excluding bulk storage of materials that are flammable or explosive or that create hazardous or commonly recognized offensive conditions. So I think that the operative words that we should be looking at are a use involving storage, wholesale and distribution of manufactured products, supplies, and equipment. And when this project started, it started at site plan review, and 2 documents were submitted to the site plan review committee. One is exhibit number 6, which is the site plan of the 9,000, whatever number it was, 400 or 500. And the building was described there on the plan, and this is exhibit 6 to my material, as proposed warehouse, 120 feet by 80 feet, and it was accompanied by that graphic that's over there that says H.H. Snow Warehouse. So we think it is in fact a warehouse, and we have a case to make to you that it is. So if those are the types of relief that are being requested, then we have a number of arguments to make to you that the project is not eligible for a special permit for storage. It's not eligible for a special permit for accessory commercial buildings for storage. And even if it were eligible for those 2 types of relief, it should not be granted because my clients believe it will in fact be substantially more detrimental to the neighborhood than the currently existing uses. So, before I dive into those arguments, I want to give you some information. And this again has to go with the request for relief, because I think if the board looks carefully at the application, there was a request made for expansion, alteration, or change to a pre-existing non-conforming use. But in the presentation, we didn't hear a whole lot about what is the pre-existing non-conforming use. We did hear that the building is accessory to a permitted commercial use. So we took a look at what's going on in the property, and there are 3 separate businesses as far as we can tell. One is the fuel business, and it is known by the corporation or moniker of Snow's Fuel Company, and this board has granted relief in the past for this particular use. In fact, in 1999, the board granted a special permit to allow that pre-existing non-conforming use that the board had found was on the property as far back as 1925. And relief was granted for expansion of the storage capacity from 27,000 gallons of liquefied propane to 40,000 gallons. So there's the business of the fuel wholesale and delivery. There's the one that we all know when we drive by, which is the home and garden retail operation. And then there's something more new, and Mr. Snow has talked about this at the ARC meetings that we went to. And the new business that's on the property is a teak business. There is a corporation known as Howland and McGregor, and these are included in my materials. It's a relatively new limited liability company that was formed by Mr. Snow and some of his family members. And apparently, from what I can gather, and I may be corrected when I yield the floor here, but from looking at the internet and the Secretary of State's website, it appears that Howland and McGregor purchased a business called Britain America, if I'm getting that right, which is a business that imports teak furniture from Thailand and then sells it. And it's I took some screenshots from the website. There's a nice quotation from the former owners. They were all very happy about selling the business to McGregor and Howland, and happy that it would proceed forward. And Mr. Snow, and I sympathize with his situation. He had said at the ARC that being a brick and mortar store in these days with the internet requires adaptation, as you heard them say, and trying to compete with the likes of Amazon and Walmart. And so what is happening here is Mr. Snow and his family are adapting. And what they've done is they've created or purchased, I should say, a new business that they're running at the property. The business address for Howland and McGregor is 22 Main Street. The business address for the Home and Garden Center is 22 Main Street, and the business address for the fuel company is 22 Main Street. Gather my thoughts. So we also went online to take a look at how ordering is done about the teak business. And there's a website, a very nice and elaborate website. The furniture is ranges from a couple $100s to a couple $1,000. Orders can be placed from anywhere in the world on the internet, and the website makes clear that all orders ship from Orleans, 22 Main Street. So why is that important? It's important because of what is the use and what is the relief being requested. And as I said, the definition of warehouse is a use engaged in the storage, wholesale, and distribution of manufactured supplies and equipment. And we would submit to you that the importation of teak furniture, the sale of it, and the shipping of it from this property is poster board warehouse. Mr. Snow also said in his presentation here, or maybe Mr. Singer, that he has several other storage facilities around the Cape right now in Brewster and Harwich that he's consolidating, and he has another location as well. He has a store in Harwich. And on our information and belief, his intent is to consolidate all of the warehouses here in the Main Street location, and then not only do the teak business, but stock the store in Harwich. This is all going to lead somewhere when we get to the accessories and other uses. So, segueing to that particular point, we have three arguments why this use is not eligible for the relief being requested. So, first, is it an accessory structure? And if so, what use is it being put to? Okay, it's dry storage. If one goes to the use table, there is a use for wholesale and storage, and in the GB and the VC districts, storage is not allowed. It's not allowed use. There's also listings for accessory uses in the use table, and I won't bore you with all of the line items, but in none of the line items is there a line item for storage. So it is not allowed as an accessory use under the zoning bylaw, and the zoning bylaw is very clear when it gets to the use table. It says all uses are prohibited unless expressly permitted. So we argue respectfully that there's no basis to call this an accessory, there's no basis under the use table to grant the use as an accessory to the retail operation. Assuming arguendo there was some basis for that argument, then the argument becomes this: what is the use accessory to? So we heard evidence about Christmas supplies coming in early, Weber grills having to be ordered in mass nowadays so that the manufacturer makes the smaller business operator do all the storage for him. So that gets us to the point of the 2,500 square feet. And so the request for relief before you is for 7,400 square feet, incidental to the retail operation. I would submit to the board that the applicant needs to make a compelling case to you that the 7,400 feet is necessary as incidental to the retail operation, not the teak business, because that's different. That's a new business that is not accessory to the retail. It's internet-based, sent over the cyberspace and mailed out from Orleans. So it's our contention that it is not an accessory use and that a case has not been made to justify a building larger than 2,500 square feet. Now, let's get to the request for expansion of the pre-existing non-conforming use. So if the argument is that the building is being built as expansion of a pre-existing non-conforming use, the question becomes then is, well, what is the pre-existing non-conforming use? And there's evidence in the record. This board has determined that the fuel storage there is in fact protected. It's grandfathered. It's been there since 1925. So if one were to make a case that the proposal for the board today is to seek a special permit to expand the fuel storage into the warehouse, we have the following to say. Under the Powers test in the Blasco case, our courts determined and hold that when there's a pre-existing non-conforming use, There can be natural expansions of the use. There can be enlargements of the use. There can be changes to the use to reflect modern technology that make things more efficient. But when a use changes so much that it becomes a new use, then the new use has to comply with your current code and is not able to bootstrap itself under the old pre-existing non-conforming use. So the request for the board to rule on tonight is for dry storage. That's completely different than the protected use that's on the property. The protected use is storage of oil and liquid propane. The request is for dry storage in a warehouse. So we would respectfully submit that it is not a change, extension, or alteration of the pre-existing use on the property. There's further evidence of that too. As I mentioned in my preamble, Snow's Fuel Company is either a corporation or an LLC. I provided the board with the documentation, but it's a separate entity. The Home and Garden store is a separate entity. The teak business is a new entity that was formed in an LLC in 2015 and taken over by the Snow family through that corporation. So it's not even the same entity that has the pre-existing non-conforming use. It's a completely different business that's seeking a warehouse on the property. Another nuance of that argument about the extension, alteration, or pre-existing use is the fact that the applicant is asking for a new building. And I know that someone earlier said that this is becoming legalistic, and I don't mean it to make it that way, but there's a very important threshold that's being crossed. The case law about pre-existing non-conforming uses is fairly clear that it stops short. In other words, that a person that's seeking to have their grandfathered use expanded, that does not come under the heading of erecting a new building. The courts have drawn a fairly bright line on that particular issue, saying that that is a new use, and the new use in the new building has to comply with current code. And under current code, warehousing is not allowed in the GBVC district. So for those, and these are articulated more completely in my papers, but we have the alternative argument that if the board finds the applicant is eligible and finds the relief request is properly before you, then my client argues that the proposed project will be substantially more detrimental to the neighborhood than the existing uses. The existing uses, as I've described pretty completely, are on the property, but there's been this wonderful buffer between them and the residential uses that are the condominiums. In fact, the expansion that Mr. Snow was able to obtain from the Cape Cod Commission was specifically conditioned upon restricting the area that is now currently proposed for development. That was a very specific condition on the DRI approval. Mr. Singer was very clear that has now been removed. We're not arguing that. It went to town meeting. It went to the Cape Cod Commission. In everyone's infinite wisdom, that commitment that was made was allowed to be reversed. But the issue now is the proposed building is in that buffer from the residentially developed properties and the fuel business and the home and garden center. And we've heard things that this is a innocuous use, it's got no plumbing, et cetera, but it is surrounded by residential properties. It's adjacent to the condominium. It is commercial use in an area that has been developed residential. I know that it is commercial zone, but it's been developed as residential. It is out of scale, as you heard me argue earlier, and I won't restate everything. It's, in our view, 2 times as big as one of the condominium buildings, 4 times larger than the surrounding houses. Despite Mr. Snow's admittedly efforts to try to make it more palatable, it's still architecturally incompatible. It's still a very large monolithic building that's going to be behind my client's property. My clients believe that it will adversely affect their property values. They recognize the BSS whooshing sounds that have been put on the forklifts, but we all know that warehouses get deliveries from outside contractors, and they usually come by big truck, either a box truck with 6 wheels or an 18-wheel truck. Those have beepers. They also have diesel engines that, particularly in the winter, the drivers idle, and sometimes they arrive in the middle of the night because they don't want to have to fight with traffic. So my clients are concerned about noise, they're concerned about pollution, they're concerned about activity in an area that presently serves as a buffer to the commercial uses, and also the views in the winter, as Mr. Earhart said. We were there in the winter when this project began, and it's easily seen through the woods. So, for all those reasons, we think that there's a legal problem with the basic request for relief that's before you, and we believe that on the merits, the proposed project will be substantially more detrimental to the neighborhood. Thank you.
Thank you, sir. You have a question?
I saw at least one other hand raised. I believe there's one other person that wished to speak.
Oh, I just had a question. Sid, since you have no sprinkler system, is there a hydrant nearby, or what happens if there's all this wood furniture?
There's two hydrants, there's one on the bike path, and there's one on Main Street.
That's my question. Thank you.
Yes, sir.
For the record, Jim Earhart again.
Thank you.
Just want to make sure we're clear. This building started as 9,400, popped down to 74. That wasn't done for us. Sid told us that he did that to get away from putting town water in because he had to have a fire suppression system at 9,400 square feet. But at 74, he didn't. So I just don't want you to think that it's for our benefit. It's going 2,000 smaller. It's still 3 times the size that's even permitted if it was permitted. And the other thing, just to go, in my professional career, I've dealt with zoning restrictions on vehicles for over 3 decades. And they always say, gonna deliver, blah, 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 8 to 4. But what happens, these trucks come and they park these 18-wheelers running in the middle of the night behind Ocean Edge, where I dealt with them a lot, loaded with condominiums, and they're not delivering. They're just sitting there waiting until 8 o'clock comes, then they unload and deliver. So that becomes a problem. And there's no way to communicate to all these suppliers that come to these places because they don't know the restrictions locally. They just show up in the middle of the night, usually in the middle of the night, or very early. So just a point of information. I won't say anything.
No, we're not trying to restrict you.
That's right. I don't want to talk to them. But I just think we should have all the facts. Well, let me talk then. I bought that condominium. I live in Brewster, but I'm an owner of the condominium, one of the buildings that's adjacent to this new warehouse. When I bought that property, I went to the deed title search with my attorney, and I was provided the deed to that property, which showed there was 4 acres of conservation land forever, it says, in the Cape Cod Commission's documents, that 4 acres. Well, I learned that forever is not forever. And this is the only time I've ever heard of on Cape Cod, and I've lived here all my life, that somebody has been able to buy that conservation land back in exchange for another piece to put a warehouse or something on it. Mr. Singer alluded to the fact that all these little things went on that permitted approval. Well, granted they did, but we as abutters had no notification. And it did go to town meeting, but all it said was 22 Main Street. It was an exchange of conservation land for something up in South Orleans, I guess. Well, that meant nothing. They didn't say that we're putting a warehouse or now it's become an accessory building on that property. It was an exchange. So I feel as an owner, I have become duped by this conservation land. I suffer monetarily because this is going to affect our values. We have 50 units in there with $20 million assessed valuation. And we are residents of the town for the most part of Orleans. And we are the public also. And these roads that go in are not restricted to private use. You can go in the Oaks as a public, you can drive around. Under Chapter 9, you are considered the public unless you're barred from that. So we aren't secondary citizens being in there. And I think Sid Snow has done what he can do. He has motivation for it. We also have motivation to protect our interests and our lifestyles. And clearly this building is going to be something we do not want to see. And Mr. Snow did say it's become a legal issue. Well, unfortunately, it has become a legal issue. I think that's all I have to say.
Thank you, sir. Are there any questions by any members of the board?
No.
Mr. Singer, do you wish to address any of the specific points brought by Mr. Wall? I think it might be helpful once and for all that here on October 18th that you define exactly the relief that you're looking for.
Thank you, Mr. Chairman. Actually, I'll respond to that point and to the legal questions, and Mr. Snow would like to respond to some of the operational questions. As to the relief specifically that's being requested, clearly special permit for more than 2,500 square feet in gross commercial use. Special permit for that. I included the request for the change of the pre-existing non-conforming use, in part because historically, that's how the town has, the Board of Appeals, has reviewed this property over the years. And we are not doing anything to the fuel storage business. We're not creating a new business. It's an extension of the retail business, and I'll get into that legally. So what was non-conforming on the site, in part was the the multi-use aspect of the Snow family business. The fuel storage was part of it. We didn't get into it tonight, but there were dimensional non-conformities at the front of the property. Setbacks, parking, all that. But that's why the site was, I mention that only because that's why the site was seen as pre-existing non-conforming. This is a conforming structure on a conforming part of the land, an allowed part of the land. If the Board of Appeals feels that we only need the special permit for the more than 2,500 square feet, I'm happy to withdraw the other part of the relief request without
Well,
prejudice.
apparently it's confused the issue a little bit.
And if it has, I apologize for that. The reason I said why I did it is, that is how the town has historically looked at it, and I was, the Board of Appeals, and so I was maintaining how we've been before you. Prior to that, it was my father was before you, on behalf of the Snow family. So that's why I had it in there. To the extent that it's causing confusion, and/or you, because it's up to you, determine that it's not necessary, then we'll withdraw that.
Because there's nothing dimensional here.
No, this
Question
building is conforming.
And your contention is that it's an accessory use.
No, actually. It's my contention that this is an accessory structure for the allowed retail use. I think
Yes.
that's an important point. Well, Mr. Wall was saying that this was a new use of the property, or there was a change of use on the property.
I'm not sure what Mr. Wall said. I want to make sure we have crystal clear
Yep.
what you're saying. And that is, it's an accessory use to the present retail business. And it really doesn't make any difference to the board, we may say, whether linens or window treatments or children's games are being stored there. It's dry storage, has nothing to do with the sale of fuel products.
Correct, absolutely.
We're all on the same page about that.
We are on the same page.
So the fact that you come in here talking to us or to the Cape Cod Commission, that you're gonna put Weber grills in there or teak products is of no consequence whatsoever. It's
Legally, that is correct. It was just an attempt to be clear to the board what we were proposing.
I'm hearing basically that the objection is to the siting and the size of the structure.
That's what I understand it to be, yes.
And Mr. Snow has said, well, we've tried to mitigate this, and the question is, what do you have to do for landscaping before a part of a piece of property becomes so invisible that it's pretty much exempt from zoning altogether, because nobody sees it, hears it, smells it?
I believe that's why the threshold you look at is substantially more detrimental, for that very reason. It's not that it has to be invisible,
No, but
it has to be reasonable.
But you're saying, you've been arguing that the logical extension of what you've been telling these board members and myself is that you've done everything you can to buffer that property and make it invisible to the senses of the people who live closest to it.
Correct.
Okay. I interrupted you.
That's fine. You're the chairman. Or any board member may, please feel free to as I'm talking. So yes, everything you said, I do agree with. And so some of the other responses I wanted to mention, and this gets to, excuse me, the adaptation. Businesses do adapt, they have to. Fuel storage actually, or fuel business, which I heard tonight, I didn't remember, was there on the property since 1925. And when the Snow family started in the 1800s, they didn't sell fuel because they didn't have fuel.
Deliver coal.
At
So-
coal, or a different type of fuel. And so businesses do adapt, and there is nothing that says, just like there's no specific limitation on what a retail product can be, could be sold, there's also no limitation on the number of legal entities you may have operating your business. People have a business, they own the property with one LLC, and they rent it to another corporation, and then they have other sub-corporations. That's all the legality, so I don't believe, Mr. Wall took pains to say that there's a new teak business, and this is a new use that's not allowed. I don't believe it is a new use. I believe that it is just another facet of the retail use, and how Mr. Snow and his family choose to legally incorporate their various functions of their retail business. As you heard, there are multiple ones already. I don't believe that that's a prohibition. I just believe that is how modern businesses function. As far as the term retail versus wholesale, yes, Mr. Snow has used the term warehouse when he's talked about the building, and that is in common parlance. Anything that's a big building is a warehouse. You could call the retail building a warehouse because he has an awful lot of storage in that front building. But that's where he sells out of. The lumber store across the street, and in the other towns they do as well. So it's not. It's not what you call the building. It's what the zoning bylaw defines it. Now the zoning bylaw does define wholesale business warehouse, and that use is not allowed in the zone. That is a use engaged in storage, wholesale, and distribution of manufactured products, supplies, and equipment. None of this product is being sold wholesale. If I want to buy a teak chair, or if you would like a teak desk, you may go down to Snow's tomorrow and buy it on site. So yes, you could go online and go to their website and order your teak furniture or your charcoal grill or whatever might be in the building. But you could also go onto the store and buy it. So what is being proposed, again, is not a warehouse. It's not the storage for wholesale use. It is not a use itself, as we just discussed. It's accessory to the retail use of the property. And I think that's important for the board, because again, it's a conforming accessory structure with an extension of a conforming retail use on the property. So those are all allowed. And I think actually with that, Mr. Chairman, I'll turn it to Mr. Snow, who would like to briefly talk about, or anything to add about some of the businesses, or the aspects of his retail business.
Yeah, I mean, Andrew covered a lot of it, but just for the record, since it was stated that this was a warehouse, and warehouse is defined as wholesale business on the zoning bylaws. As Andrew said, it is not a warehouse. We had an opportunity to buy a company that sells finished teak benches primarily to universities and colleges, municipalities, and churches throughout only the country. It's not global, and primarily it's in the Northeast. And so we had an opportunity to purchase that business, and we continue to do that with some big universities with benches. We also have been selling that same product in the store for about 15 years under the British American label. So we rebranded it, Modern Times, to something that we felt was a little more fitting, and so we call it Harlow McGregor. But we actually sell more than what we sell retail to institutions in the store. We have a need for a lot of extension tables and different variety of more fashionable teak products. And it's also wanted to say that that the 7,400 is not inconsistent, because the space actually that is currently being occupied by Harlow McGregor Teak Products is less than 1,000 square feet storage, and I don't expect it to be expanding by any significant amount. Also, just for the record, I have recently, done some restructuring of the companies, and so all my businesses are separate LLCs now. And the store is at 22 Main Street. Fuel has been for a while, but it's 18 Main Street, and Harlow McGregor is 20 Main Street. We did that primarily for Google searches, so advertising marketing is more social these days, and Google kind of bites into a lot of things, and so we wanted to minimize the confusion to consumers as to who's where on that 10-acre parcel.
Thank you.
Maybe you better correct the Harlow and McGregor website, which has it listed as 22 Main Street.
Yeah, thank you.
Another part of social media is catching up to all these changes.
I think
Make a note of that, thank you.
it's not any great consequence. I just wanted to correct you. Are there any questions? Mr.
You ask Mr. Wall a question?
Yes.
Okay, Mr. Wall, what if Mr. Snow offered to build like 2 buildings near each other with pitched roofs, fake windows? Maybe they were connected by an enclosed fire-resistant corridor. They could drive forklifts back and forth. What about something like that? Do you think that your association would accept something like that? 2 buildings that looked more like homes and more in conformity with the character?
I'd have to consult with them.
What do you think, just,
I don't know what my clients think until I talk to them about it, with all due respect. I represent a group.
I understand, but what I'm trying to see is there any leeway here between no building and different buildings?
The way I'll answer that question is that the proposal before the board is for a 7,400 square foot warehouse
Mhm.
adjacent to a residentially built out property.
Right.
And the residents think it's gonna hurt their property value and affect their way of life, and
Mhm.
that they don't want the building that's proposed.
Okay, and you won't comment on whether they would accept some sort of a compromise? You won't comment on that?
I think that the way that I've pitched the argument here is that there are legal problems with it,
Mhm.
and that I don't think it's appropriate to negotiate in public about what my clients might want or might not. You know, very often when you go to court and the
Yeah.
judge says to the parties, have you talked about settlement? The way you answer that question is, yes, Your Honor, and as Mr. Singer, correctly said, we're always willing to talk. My clients are willing to talk too. But once you get into the specific proposals and
Mhm.
rejections and acceptances, then an opinion can be formed about whether that person's reasonable or unreasonable. And that's what I'm very afraid, once I start down that slope, there might be opinions made that, well, Mr. Snow's project is reasonable, my clients are unreasonable. And my clients might think that it's unreasonable that Mr. Snow hasn't done more. That's all a gray area subject to perceptions and opinions.
Okay, I understand where you're coming from. I just wondered if you had talked about compromises or options with your client.
I have, and I've also talked to Mr. Singer about this. He told me, I told him noise was an issue, and to Mr. Snow's credit, he came up with that whooshing thing.
Mhm.
And Mr. Singer emailed me the website and gave me that information.
Okay,
Beth?
thank you.
What is the noise like with deliveries at Snow's now?
Oh.
The trucks coming in?
Thank you for bringing it up because it was in my notes. Right now, I estimate, and he's correct about truck drivers that, get there early and they park overnight and wait for the store to open. The average that's happened is maybe 1 or 2 or 3 times a year. A trucker will come to the Cape that early, and usually the cab is off, and the engine's not running anyway. And as far as deliveries, we stated that I have to take all of my seasonal deliveries in December, January, February. Most of them come, some of them in March or November. But I take pretty much all the stock that's going to be put in that warehouse is going to come in that 4 or 5 month period. And it's usually averaging right now, I probably get maybe at the height of the season, I'll get 1, 2, or 3 trucks a week of storage coming in. When Weber Grill comes in, it's a whole 63-foot trailer full of just our stock, and it just gets put in the warehouse.
Okay, and as far as when those deliveries are made, do you have any kind of control, like you're suggesting here, the 7:30 to 6?
Yes, we do. We contact the transportation company, and we explain to them our issues that we have with the town and abutters, and they say they put it into their computer systems, and for the most part, they abide by that. Is there going to be a mistake that's out of my control? Yeah, there may be.
Right, okay.
If we could also, just from a practical point of view, when you look at where the building is, you have a very narrow driveway that it's for the fire department safety, but it's narrow. It's not like a big parking lot.
Right.
So someone would, even if there was a mistake, odds are they're not gonna drive all the way back there. You actually, down a hill, around a corner and through the
No,
woods.
they would never park
Do you
overnight.
chain it off prevent trucks from coming back
There is a
in?
gate there.
Gate,
There
okay,
is a-
so it's gated, okay, thank you.
Let the record reflect that there are, the file does not contain letters of correspondence from any individuals or organizations either favoring or in opposition to the application. I think,
Other
yes.
than the one I submitted, right?
Oh, no, no. Yours is accepted. And tonight too is further accepted. I'm thinking of closing the hearing for the taking of evidence. Very well, then I will. And let's discuss it. What is the sense of the board?
I would vote to approve the special permit.
I agree.
Agreed?
Mr. Jablon.
You know, in my heart, like being a resident and a taxpayer here, property owner, I don't think I'd really like this in my backyard. However, I asked that question, kind of loaded question, for a reason about would anything else be acceptable? Because with all due respect to all the parties present, I don't see where the Oaks has tried to negotiate any kind of compromise. I may be wrong about this, but I get the sense that it's an all or nothing sort of deal. And it could be a lot worse, you know, that warehouse. It could look a lot worse. It doesn't have to have the, I don't know what you call those, shrubberies and things like that. So, having said that, I think that I'm going to go ahead and vote for it to be approved.
You know, Mr. Jablon, the board, when at appropriate times, has recommended to individuals who were in dispute
I know, I was
to
there.
mediate, and I can recall you in particular making some very heartfelt remarks recently. But on the other hand, what you're really saying is, and the problem with the entire, if we'll call it controversy, is a question of degree. To what degree does a structure that would otherwise be permitted on a parcel of land under the zoning bylaw be acceptable as part of a neighborhood, even though we're straddling districts? It's tricky, and there's no calculus to determine any scoring.
Right.
So that's the difficulty.
And Mr. Snow's made an effort,
Yeah.
but there's no wiggle room, it doesn't
That-
seem.
That's right. So what we have is this application
Mhm.
before us, and I will entertain a motion to grant the special permit.
So moved.
Mr. Jablon, is there a second?
Second.
Any discussion on the motion? All those in favor?
Aye.
Aye. And opposed? Motion carries unanimously. I will write the opinion.
We appreciate your time. Thank you very
Thank you.
much for your consideration.
Thank you, everyone in attendance. Is there any further business to come before the board? And we'll entertain a motion to adjourn, please.
I move to adjourn.
Second? All those in favor?
Do you want any of these?
Aye.
Motion is allowed, and the meeting is over.